Dear audience, uh, learners, I'm dealing with a very sensitive and practical topic, that is will or wasiyat under Muslim law. I have already dealt with various aspects of this topic, beginning from the conceptual analysis, that is introduction. Then I try to explain the meaning or concept of the will as understood under Muslim personal law or in context of the Muslim law. At the same time, I try to explain the basic objective of this law, that is law relating to the wasiyat. What is the objective, what is the purpose of making the provision for a bequest or wasiyat. Then, ladies and gentlemen, I discussed the necessary formalities for the making of a valid will under the Muslim law. Now, today I propose to discuss essentials of the valid will, or what are the essentials or prerequisites of a valid will under Muslim law. Repeatedly, I am making the reference of the word Muslim law, reason because the provision for wasiyat or testament is not only under the scheme of the Muslim law, but the provision for making the wasiyat is also given under the secular law dealing with the devolution of the property of an owner. Therefore, scheme or provision for making a will is also given under the scheme India under the scheme of Revenue Code 2006, because Revenue Code 2006 has a complete chapter within its structure dealing with the devolution of the interest of a tenure holder in his property by various legally recognized means or mode. And one of the mode of the devolution of the interests of a tenure holder in his property, even under the revenue code, is that mode is known as wasiyat or will or testamentary disposition. But learners should keep in the mind that a provision for the wasiyat or testamentary disposition under Muslim law is entirely different from the provision of making the will given under the scheme of Revenue Code 2006, which is applicable to all the citizens of this great country across the religion. And therefore, the rules are entirely different. Rules regulating the provision of the will or making of the will under Muslim law are entirely different from the set of the rules given under the other laws. For example, under the Hindu law, under the Indian Succession Act 1954, as well as under the Revenue Code 2006. And the basic and fundamental difference between the two set of the laws dealing with the validity of the will are that in other system, restriction on testamentary power are very limited in their nature and scope, but limitation operating on the testamentary power under the Muslim law are little bit wider in range as well as in effect. For example, wasiyat in favor of the legal heir is invalid under Muslim law. I will discuss it under a different heading. But this type of the restriction is not under the Hindu law or under the uh, Indian Succession Act 1925, and even this type of the restriction is not given under the provision of the revenue code dealing with the or controlling the validity of a will under the revenue code 2006. There is a philosophy, there is a reason for placing the restriction on the testamentary power of a Muslim testator. A reason I have already explained when I dealt with the objectives of the wasiyat. Therefore, friends, in order to distinguish rules regulating the validity of a will under Muslim law and the rules governing the validity of the will under the other systems, other laws, it is necessary to discuss distinctly the essentials of the valid will under the Muslim law. What are the prerequisites for a valid will under the Muslim law? Because it is a transaction between the two persons, and therefore the transaction to be regarded as valid, effective and capable of taking the effect at the prescribed time, it is necessary that it must have been made. The transaction is the will, and therefore it is necessary that a will to be valid and making it capable of taking effect after the death of the testator. It is necessary that it should fulfill certain conditions, and the conditions which are necessary to determine validity of the will are also known as prerequisites of a valid will or essentials of a valid will, or the basic features of a valid will under Muslim law. Ladies and gentlemen, under Muslim law, for a will to be valid and capable of taking effect in law after the death of the testator, it is necessary that it should fulfill certain requisites or certain conditions or certain requirements which are must. And the requirements which are must for a transaction to be regarded as valid will and capable of taking effect after the death of the testator, according to the rules of Muslim law, it must satisfy the following conditions or following requisites, and they are, I point out, number one, testator should be competent to make the will or wasiyat or bequest or testament, whatever. This is the first and foremost prerequisite for making a will to be valid, capable of taking effect after the death of the testator. Dear learners, next to it is that the legatee should be competent to take the bequest or will made in his or her favor. The third and very important prerequisite or precondition for a valid will is that it subject matter of the will should be valid one. Then the last but not least and most important condition for a valid will prescribed by the Muslim law on the subject is that bequest in question should be within the permissible limits of law. So these are the four conditions for a valid will, and these conditions have been prescribed by the Muslim law itself, and therefore testator is required to make the will, may be oral or may be in writing. Testator is required by Muslim law that while making the will of his property, he or she should take care of these conditions, means wasiyat should be created or should be made or should be executed taking care of all these four conditions. Reason because where a will has been made by a testator, Muslim testator, and the will be opened or will be operated only after the death of the testator. However, before giving the effect to the will made by the testator in his life, it will be examined whether the will in question is valid or not after the death of the testator. And to determine the validity of the will in question, it will be examined on the parameters, on these four parameters which I have just indicated one by one, that a testator should be competent to make. This is one of the parameter laid down by law itself to examine the validity of the will. The next parameter is that legal parameter to measure the validity of the will or to decide the validity of the will, that legatee should be competent, so on and so forth. If it is the will was made by the testator in compliance of these four conditions, on the face of the record, the will be valid and will be capable of being operated or given the effect after the death of the testator. If the will is found on scrutiny in violation or in contravention of all these or any one of such conditions, then will be regarded as invalid, unlawful, and will not be liable to be operated after the death of the testator. Bequest will be considered redundant, and the property which was intended to be given to the legatee by the testator while making the bequest will go to the legal heirs on his death by way of inheritance or law of succession. Therefore, whosoever is intending to make the bequest of his property and testator in the given circumstance happens to be the Muslim, then the bequest must be taken by him in strict compliance of all these four conditions. Else, exercise will be futile, it will be a mere piece of paper, and the legatee will be only the expectant. And on the death of the testator, when his expectation would be at the verge of completion, he will go the empty hand, because the will, though on the face of record, was made in favor of the legatee, but legatee will not be legally entitled to claim anything pursuant to the will because of its being inviolate due to the made in violation of these conditions. Ladies and gentlemen, now I proceed to examine these prerequisites or essentials of a valid will under Muslim law one by one in detail. First, that is competency of testator, that is the testator should be competent to make the will. This is the first and foremost condition for a valid will under Muslim law. Competency of testator in context of the testament means the person who is making the will be known as the testator, or the person who is disposing of his property by means of the testament, that very person is known as the testator. Therefore, law requires that the person who is intending to dispose of his property by means of testament or by means of the bequest or wasiyat or will, at the time of making the will in respect of his property, he must be competent. Now, expression competency here means that he should be legally entitled to make the will or to dispose of his property by means of the will or in the exercise of the testamentary power conferred by law on him. Ladies and gentlemen, according to the rules of Muslim law, every Muslim, male or female, who is of sound mind at the time of making the will, as well as has attained the age of majority, will be deemed by law to be competent to dispose of his or her property in the exercise of testamentary power given to him by his personal law or her personal law. Therefore, under Muslim law, a testator, every person, a testator will be deemed to have been competent if at the time of making the will he fulfilled the following two conditions, or he satisfied the two conditions. Number one, that he was a person of sound mind, and he was of age of majority. Therefore, every Muslim male or men and women who is of sound mind and has attained the age of majority at the time of disposal of the property by will be uh, will be regarded by law as competent testator. Therefore, only the two conditions should be satisfied by the maker of the will at the time when it is being executed, either oral or in writing. What are those two conditions? They are that the testator should be of sound mind at material point of time. What is the material point of time? Making of the will. The second is that he should be a person of, he should have attained the age of majority. Now, very natural. What is the meaning of expression sound mind in context of testator vis-a-vis the will? Ladies and gentlemen, the expression sound mind is a legal proposition, and therefore to be competent to make a will, the testator must be physically and mentally fit at the time when the wasiyat is being made by a Muslim testator. That is the person who is making the will of his property. At the time of making the will, he should be physically and mentally sound. It means he must be perfectly in sound frame of the mind at the time of creating the will or making the will. Therefore, the expression sound means in the context of the bequest would imply that he should be capable of making a rational decision. Very important. Who would be deemed to be person of sound mind? Law requires that the test to decide testator at the time of the making the will was of sound mind, he should fulfill the one thing, and that is that from his action it must appear that in the given circumstance he was capable to make or to take a rational decision on the matters of his own interest. In other words, he must have been capable to distinguish what is right and what is wrong for him. Means he must be capable enough to distinguish between right and wrong, between good and bad. Further, he must be capable to assess the nature and consequences of the transaction being undertaken by him. So means the testator was a person of sound mind will depend upon his decision making power in a given circumstance on the subject before him. Because in wasiyat, basically owner intends to transfer his certain part of the property to another person of his or her choice, which is to take effect in future, that is after his or her death. And transfer of the property in natural course involves the transfer of the bundle of the rights in respect of the property. And transfer of the property, no doubt, brings out certain consequences, legal consequences, societal consequences it will have. What will be the legal consequence? That the moment he dies, if he made a will in his lifetime in the name of someone else, and thereafter he dies, so at the time of making the will, he must be conscious enough that whatever decision he is taking, that will have certain legal consequences. And what will be the consequences? That on the death, property intended to be given to the legatee will not go to his legal heirs, but it will be the claim of the legatee or legatees if it is otherwise found valid. Means his legal heirs will be deprived of this property which has been made the subject matter of the wasiyat by the testator in his lifetime. And what kind of the economic impact it will have over his own legal heirs? Will it render the property less to the legal heirs? Will it not have any impact on the economic status of the legal heirs? So, at the time of making the will, the testator should have been capable to assess all these things in legal perspective. If it was so, then he shall be deemed to have been in a position to take a rational decision. Therefore, a Muslim who is incapable to take a rational decision due to the mental illness, due to physical infirmity, due to attending facts and circumstances adversely impacting his decision making power, will be deemed to be incompetent to make a will. And if he declares a will and subsequently is cured of the insanity, the will would still be invalid. A person of sound mind and measure, if makes a will and subsequently he becomes insane, the will made by him would become invalid provided the insanity is of permanent nature.